Good afternoon, everybody. It's Jeff Jenkins and Eric Clayman again. And just to remind you, we're the partners at Jenkins and Clayman, one of New Jersey's premier bankruptcy firms. And we're here for the 20th episode of our Facebook Live series every Thursday at 2 p.m. Now, last week, we were about halfway finished and Facebook decided not to work anymore. They might have been overwhelmed with all the political commentary being put on Facebook and having to police it all up. I don't know, but here we are again, and we're just.
I thought it was shut off because we had so many viewers. So many people were commenting and asking us questions that they just couldn't handle it.
Perhaps, I don't know. So last week we were talking about the myths about bankruptcy, and a lot of times people call us up on the phone and they'll say, well, I heard that you can't file bankruptcy anymore, or you can't get rid of all your debts anymore, or this or that, or they might say that when they come in to see us. And that's where we're getting these things from, and where do they hear them? From any number of places. Their friends, if they've been to an organization that's going to attempt to negotiate their credit cards for them, a lot of times that's the nexus of the myths, because they want them to do business with them, not go to a bankruptcy attorney. And so they're going to say, well, you don't want to file bankruptcy because you're going to lose all your assets, like your property and your retirement savings, and so on.
That's a myth. That's an interesting myth. Why don't you talk about that?
It is. Well, I read it, so I thought, that would be good. All right, so that's the first thing I'm gonna talk about. When you do a bankruptcy, you're not going to lose all your assets, property, retirement savings. First of all, in New Jersey, any retirement savings that you have is just strictly off limits. It's not part of the bankruptcy deal. I don't care how much you've got in it. You could have $5 million in your 401k or something, and it's just immune from anybody grabbing it with the bankruptcy going on.
Maybe one exception is if you have an IRA and you load it up before.
That's why I said 401k.
Okay, gotcha. But you can't just load things in there, sell all your assets and throw it in. But
Right.
We've never had a client do that.
No.
And you're right, in New Jersey, not in every state, Jeff, but in New Jersey, it's 100%.
Yeah, and it is because New Jersey passed a law in 1993 that retirement accounts were exempt from creditors. And in that, when they passed that law, I looked at it and I went down and they had every section in the Internal Revenue Code in there. You talk about the section for retirement accounts, they had every one, for the IRA, for 401k, for everything. And then later the highest federal court in this area of the country, the Third Circuit Court of Appeals, ruled on how that law would operate in a bankruptcy and concluded that it would shield all retirement accounts were shielded in a bankruptcy in the Third Circuit. So, you're certainly not going to lose your retirement savings. As far as assets and other property goes, when you do a bankruptcy, you're allowed to have a certain amount of belongings, and those are covered in the exemption section of the bankruptcy code. And the exemption section says you can have so much in equity in a home, in furniture, in clothing, jewelry, a vehicle, firearms, whatever. Although we'll talk about that another day.
We're prepping for next week's show, by the way.
Right. And when you come in to see us, we spend a while asking you about all the things that you have. And if there's any danger that you're over your exemptions, you've got a wild card exemption for money you might have in a bank account of more than $10,000. The wild card exemption is like $13,000, more than 100 now.
Yes. No quizzes on live TV.
Yeah. So if there's any problem, we're going to talk to you about that. And we're certainly not going to file a Chapter 7, which if we did and you were over what you're allowed to have, the trustee could take it and sell it and use that money to pay your creditors. If you want to keep what you've got and you're over the exemption amount, we would do a Chapter 13 for you, and then let's say you're $5,000 over. It means you'd have to pay your unsecured creditors $5,000 through the Chapter 13 trustee over 5 years. or
a
less.
lot, and that's a lot less painful than having to sell assets, isn't it?
Absolutely, absolutely.
Jeff, I often, when I try to explain what an exemption is to a client, I look at it, I say it's like a shirt on your back. If you go into bankruptcy with just your shirt on your back, you keep your shirt
Right.
and you don't pay people back. But if you have a stack of cash, Congress arbitrarily set limits how much you can keep.
Exactly.
And you're
Yep.
talking about the situation where someone has more than what Congress says is exempt or protected,
That's right.
more than the shirt on your back.
And the allowances are not insignificant. They're pretty high, and we seldom have problems along those lines, but sometimes we do, and we can deal with it like I just talked about. So you don't have to worry that you're going to lose things. That's going to be just fine. Another myth that we see sometimes is that it's difficult to file a bankruptcy and it's hard to get it approved, and maybe somebody who says that is thinking about, well, they changed the law in 2005 to some extent, and that's one of the things that the new law did. I don't know, but Eric's going to talk about that. Anyway.
Right, Jeff. And you can interrupt me as much as I interrupt you, believe
Okay.
me. Hi, everybody, again. Bankruptcy petitions, the preparation of a bankruptcy petition is a very serious matter, and it demands a serious law firm with expertise in the field. As Jeff and I have explained during our 19 previous episodes, you need to speak to a bankruptcy attorney whose primary practice is consumer bankruptcy work. If you're dealing with someone who puts a ad on the internet that they file bankruptcy petitions, ask them 2 questions. You're allowed to ask, how many bankruptcy petitions have you filed in the last 3 months? And is there another lawyer at your firm familiar with bankruptcy work should something happen to you? Those are 2 crucial questions. If you went to a doctor, you wouldn't go to an orthopedic surgeon to have your eyes examined. Well, you
No,
could,
no.
but it wouldn't be a good idea. And you might want to ask the orthopedic surgeon, well, how many eyes have you examined in the last 3 months? You divide it by 2 if it's eyes examined. My point, it's serious. Our law firm has 4 attorneys right now that all we do is consumer bankruptcy work. We know how to do it. And if someone goes on vacation or someone leaves for whatever reason or someone gets sick, you have 3 other lawyers backing them up. And that's very, very important. The bankruptcy court and the bankruptcy code as written by Congress and signed into law, many iterations. There have been numerous amendments to it. But the point, what I'm going to, is that the bankruptcy petition, the document that gets prepared and filed, and the bankruptcy code, which is the law, was designed to be an open door for consumers, to allow consumers to be protected, to keep their house, to keep their cars, to stop wage garnishments, to stop the IRS from garnishing your bank account, to stop creditor calls and harassments. And the only way that would work is if the filing of a bankruptcy petition would be easy in the sense of stress. It's difficult to prepare the petition properly, but if you deal with lawyers who do this for a living, it's a stress-free situation where you talk to our firm, we fill out the petition, you review it, it's based on the information you gave us. As Jeff said, we spend a lot of time talking to clients about what they have, what they earn. We go over it and over it, you approve it, we approve it, it makes sense and it gets filed. But compared to dealing with losing your house, losing your car, being evicted, having your wages garnished, having your bank account levied, the filing of a bankruptcy petition is not that difficult. That's what we're here to make it work. Now, Jeff, I'm reading your list. Was there a second part of that myth? It's difficult and hard to get approved. No, it better not be. Okay, the approval process, we talk about there's 2 types of bankruptcies, consumer bankruptcies that we deal with, Chapter 7 and Chapter 13. And we've talked about them before. If you have any questions about them, give us a call. But in Chapter 7, you're in and out of bankruptcy in 3 to 4 months. And out means you've been discharged of your debts. A discharge means, in the eyes of law, you don't owe the people any more money, even though you're not paying them back. That's a 3 or 4 month process, and it works as long as it works. It works. It's approved in your work. Now, Chapter 13 is that payment plan that Jeff was talking about. If you have too many assets, or if you're behind with your rent, behind with your car, owe the IRS money, behind with your mortgage, there's all sorts of reasons why a Chapter 7 doesn't do everything for you. And that's why Congress wrote the Bankruptcy Code and included Chapter 13, which is a payment plan bankruptcy. That's a little longer. It's 36 to 60 months. But we're partners with you that whole time. And is it hard to get approved? No. You have to do 3 things. Ready? You have to pay your mortgage or your rent. You have to pay your trustee. And you have to have a meeting with the trustee once. You do those 3 things, we'll take care of everything else. All right?
That's right.
So, Jeff, I think we've dispelled, is that a good word?
Yeah.
The myth
Perfect
that
word.
bankruptcy is difficult and hard to get approved. But I have a myth that we hear a lot from our existing clients, actually, and clients who have already successfully completed a Chapter 7. You know, they don't ask this because they've already been solicited for credit. But here's the myth, Jeff. After you file bankruptcy, you can't buy a car, you can't get a mortgage, and in fact, you can never get credit again.
Yeah, nothing could be farther from the truth. If you file a bankruptcy, you can absolutely still buy a car, you can absolutely get a mortgage for a home, and you can certainly get a credit card. If it's going to be something major, like if you want to buy a car, or you want to buy a house, or you want to refinance your house, we need to go to the bankruptcy court and get approval. With a car, a lot of times they'll take the trustee thing from the Chapter 13 trustee, because we wouldn't think about those things in a Chapter 7, because like Eric said, they're over and done with in 3 to 4 months. But when you're in a Chapter 13 for 3 to 5 years, you may need another car. Your car might break down, you need a new car. So you can try getting a document from your Chapter 13 trustee. If that doesn't work, we can always go to court and ask the judge to approve. It's just approving post-petition financing. And in a Chapter 13, with a consumer, I don't know how much sense it makes, but if you think about that in the Bankruptcy Code, a lot of the rules are for all kinds of bankruptcy. And so if you had a Chapter 11 and you had an airline that filed a Chapter 11, right, and they want to get a loan for $500 million from somebody, and because it's after the bankruptcy was filed, it's going to have priority above things that happened before the bankruptcy was filed. So all the creditors would be very interested in what's going to go on with this, what the terms are going to be, can it be repaid, and so on and so on. So in an event like that, it's clear why why the bankruptcy court would want to get involved. But in a Chapter 13, they can with a car, they need to with a house. And I've been to, with clients, had them sell their house in the morning and buy another house in the afternoon, and they got a mortgage, and they're still in the Chapter 13. And that's happened more than once. Getting a credit card is easy, especially if you get a secured credit card where you give the bank some money, and whatever you have on deposit with them, that's the limit on your credit card, $500, whatever it is. But those things are just not true. You can certainly do all that. Buy a car, buy a house, or refinance your house, or get a credit card with the bankruptcy going on.
And what about after you've been discharged? You've successfully completed your bankruptcy case.
Well, then it's even easier. And I guess we want to talk a little bit about the credit program. Do we?
Sure, this would be a good opportunity.
Yeah.
It is true, Jeff, that most of our clients have their credit scores are low. They're filing bankruptcy.
Right.
Let's talk first about the Chapter 7 bankruptcies. In Chapter 7, as Jeff and I mentioned, it's 3 or 4 months you get your discharge. The credit cards that are on your credit report can't report negatively after you file bankruptcy. They don't have to clean things up, but they're not required to report, they're not allowed to report anything negative. So as a result, in a Chapter 7, if you've maintained your mortgage or maintained your car loan, reaffirm the debt and keep paying it, your credit score will rise as long as you keep paying your car loan. But there's more we can do to help our Chapter 7 clients, isn't there?
Yes, there certainly is. We do business with an organization that will help fix your credit report. And we pay them a little money to do business with us, but if you want them to help you get your credit report score up, get your credit report fixed, you can do that, and it's for free. You're not going to be charged a dime. It's kind of our gift to you. We did a bankruptcy for you. Now we want to help you get in good shape after, at some point, either after the bankruptcy is over or during the bankruptcy. With a Chapter 7, we need to wait until after the discharge, and then you can start working on your credit report. With a Chapter 13, our friend that we deal with will actually start working on it after your case gets confirmed. So after your Chapter 13 plan is approved by the court, we would give you his name, and if you're interested, you can contact him, and he'll help you fix your credit report. He tries to get your scores up to 720, and generally he's pretty successful with that. So
that's a good score. And again, with the Chapter 13, which is our payment plan bankruptcy over 3 to 5 years, if someone has a mortgage, they're resuming payments on that as well. And that's real good for your credit, because again, in either bankruptcy, the credit cards which we've included, which you're trying to discharge, a discharge means you don't owe them any more money even though you won't pay them back. Which you're trying to discharge, they can no longer put the negative stuff on your credit. Your credit's going to get better, but through this program that we offer for free,
exactly.
720 is attainable within about a year, isn't that generally? You can't
Yeah, a
guarantee
year
it.
or less.
A year or
really.
less.
Yeah.
That's great.
Yeah. Eric, another myth that we hear sometimes is if I do the bankruptcy, I might lose my job, or I might not be able to get hired at another job.
Jeff, we've been talking about Chapter 7 and 13 a lot today, and people who've worked here know the difference between 13 and 7, which of course is 6.
That's Eric's big joke, by the way.
And why do I bring it up? Because that's my only bankruptcy joke.
Mm-hmm.
Because bankruptcy is a serious matter. And when you have people who come into the office and believe this myth that you're going to lose your job or not be hired once you file bankruptcy, it's scary.
Mm-hmm.
But that is just a myth.
Mm-hmm.
Chapter 13 is also known as a wage earners plan. So think about that. Congress wrote this chapter called a wage earners plan. They're not going to allow people to be fired because they file bankruptcy and have a code section referred to as a wage earners plan. In fact, there's a separate bankruptcy code section called anti-discrimination. And in that code section, it's the law of the land, written by Congress, signed by the President, that employers cannot discriminate against employees or discriminate in their hiring practice if they find out that an employee has filed bankruptcy. It doesn't work. And I'll tell you, Jeff, our clients, it's not a complaint I've ever heard, I don't think. I don't think anyone, maybe you've had it, no one has ever said, my employer, Eric, I've just filed bankruptcy. Thank you. I'm saving my house, but I lost my job. That's never happened.
I don't think I've ever heard it either.
Yeah, so it's just not. And if you're unemployed and looking for a job, look, you don't know the new employer and they could be breaking the law. But for the most part, that's truly a myth that we haven't, that's just not true. People, if they're looking to hire someone, they need to fill the position. I don't even know how that would come up that you're in bankruptcy. Perhaps they can find out, but it's not anything that's considered or can be considered in an employment arrangement. So don't hesitate to contact us because you think your job is at risk. And I'm talking about, Jeff, government employees, casino employees dealing with money. I'm trying to think of everyone who you would think there'd be an issue. We have accountants, we have bookkeepers.
Mm-hmm.
It's just not
people in the military that have top secret clearances.
Right, that's a perfect example. We haven't had that as an issue. But let me give you, Jeff, a myth that we've heard, and because it's a myth, you're probably going to say it's not true, but maybe I can word it differently. The myth that paying off your debt is a better option.
Well, uh, we don't have that many clients come in here who are in a position to pay off their debt.
True.
It, you know, 1 out of 500 or something like that, I'd guess. So it's something that we're seldom confronted with. And although it happens sometimes, and if somebody comes in and you see that they have assets that could be used to pay what they owe, you could mention it to them, and then it would be up to them what they wanted to do. I mean, they could take money out of their retirement account and pay their debts. And I guess one of the things that you have to ask yourself, if this is the situation, is what's the cost going to be to me if I pay my debt off rather than do the bankruptcy? So most of the time, if you don't have some large fund of money there, you can't get a big second mortgage on your house, you don't have a lot of money in your retirement account that you can take out, are you just going to struggle for years to try to pay credit cards off at a high interest rate? And what kind of toll is that going to take on you and your family? When we have this bankruptcy available that can eliminate these things and quickly, and you can move on with your life. So generally, filing the bankruptcy is going to be a better option. But if you fall into this it is a rare category where you've got the funds to pay things, we would certainly talk to you about that and talk to you about all the ramifications of doing that.
Jeff, in the beginning of today's episode, you talked about how much time we spend with people going over their assets. So it's correctly listed in the bankruptcy petition so that we can give them advice.
Right.
There's a large number of people that call us, and at the end we conclude, well, you really shouldn't file bankruptcy. You should try to sell your house. You should try to refinance your house. You should just try to pay back your debt. There's certain situations where bankruptcy is not appropriate, and we give you that advice. But when people realize that their financial situation is such that they should at least consider filing bankruptcy, and they give us a call, for the most part, people know what they're doing.
Yeah.
And most of the time, that myth is like a ridiculous myth. What happens if I hit the lottery? Well, yeah, talk to me after you hit the lottery, We're here.
I will.
Yeah, please do. Buy me an ice cream. We're here to help people and to be kind and to understand their problems and to give them good advice. If someone just wants to talk to us and they have $100,000 in the bank and $40,000 in credit card debt, we're going to tell them, well, let's say take the 40,000. Yeah, I mean, but for the most part, if people see us, there's a reason that they're seeing us, and and we're here to help.
Right. Eric, I guess we just have one more myth to go over, and that is the myth that if your income's too high, you can't file a bankruptcy.
Jeff, first of all, there's no limit to the amount of income you can have to file bankruptcy, so that is a myth. And we have, I don't want to put a number on it, but we have more than one lawyer right now in bankruptcy, and one or two physicians, a spouse to a physician. We have people whose W-2 income is significant who've had to file bankruptcy. Why? Well, because things happen, their taxes, they're behind with their mortgage. They thought they could, remember last week's episode when I juggled?
Mm-hmm.
They thought they could juggle it.
That was unforgettable.
Yeah, thank you. That's why you remembered it. Bigger income just means bigger problems. In 2005, they did change the bankruptcy code to limit access to the fast bankruptcy, the Chapter 7. But there is no income limit. If you make a lot of money and you have a lot of bills, sometimes you still have to file bankruptcy, and the bankruptcy code was designed with that in mind. Remember what Jeff talked about? Airlines and Brooks Brothers and Hertz and all J.C. Penney's and these huge companies are filing bankruptcy. You as a successful high income earner sometimes also has to file bankruptcy. You could have invested in a second home that just didn't work out. Invested in real estate that right now you're not collecting rent on your real estate. That's a serious problem we're seeing with our wealthier clients. It's great to own these other properties and to collect rent and to have your tenant pay back the mortgage. But when the tenant's not paying you, you still owe the mortgage. Come in to see us, we can help you.
Right. Yeah, if your income's too high, and that was probably the major change of the bankruptcy law change in 2005. If your income's above the average income for a household your size in your state, then you must file a Chapter 13. You can't do a Chapter 7, and then it becomes a function of how much do you have to repay to your creditors. So that's the only, their income comes into play. How much you have to pay your creditors in the Chapter 13, the income would come into play, but it doesn't mean that you can't do the bankruptcy. So certainly it can be done.
Excuse me, just last, sometimes, remember there's two concepts that we've talked about during these 20 episodes. We haven't talked about this, the first concept really much. We've talked about the second one today, which is the discharge. But the first one is the automatic stay, which stops all collection actions, including foreclosures, evictions, wage garnishments, right on the spot. And no matter what your income is, if you're behind with a mortgage on a property and there's a sheriff's sale or other serious collection action, if you have received a lawsuit and you're a defendant and someone is suing you, you must see a lawyer right away. And you should at least speak to us about the possibility of the bankruptcy handling that lawsuit.
Right, exactly. So I think we're about finished for today. Next week we're going to talk about unemployment. And there we're going to get more into what's going on with COVID-19 and employment and how much money do I get and where's it going to come from and all those kinds of things. We might even talk about firearms and bankruptcy. We understand that's an interesting topic to a lot of people. So thanks for tuning in today. We'll be doing this next Thursday at 2 o'clock, same time, same place. You're certainly invited to watch the program. If you have any friends that are having financial issues, you might want to suggest to them that they do the same thing. And other than that, we'll see you next week. Goodbye and God bless.